the Lewis County matter. We begin with appearances on the record, please.
Joseph Thomas for plaintiff Brian Cortland.
And Eric Eisenberg for defendant Lewis County.
Good morning.
Good morning.
Mr. Thomas is the, in effect, moving party, although this is a merits hearing, so it's not a motion per se. I will hear from him first. I have one question for him at the outset, then I'll allow him to proceed with his presentation, which is if Ms. Parker had been employed by, let's say, the clerk's office or the commissioner's office or some other part of Lewis County and had done the same search that she did here, would you still have a claim?
If Ms. Parker was an employee of Lewis County, which is what I think this court is asking, I think it would be much less clear, to be honest, if we had a claim or not, because then the county is an agency and she's acting on behalf of the county, but she's not the public records officer, so I think that it would be a much closer argument, Your Honor. I don't know if I can absolutely answer that one way or another.
Understood. You may proceed.
Okay. So to go back to this court's question, a large part of this argument today is going to be about whether Lewis County had authority under the law to do what it did. The statutes that govern this case are 42.56.520, and that says that creates a mandatory duty upon Lewis County or any agency to produce records in response. They have to give a response within 5 days, and then ultimately they have to produce records under 42.56.070 section 1. And what's uncontroverted in this case, Your Honor, as you well know, is that Lewis County never responded. The Lewis County Superior Court responded. Ms. Parker testified in a declaration that Lewis County Superior Court did the search, and then they ordered Mr. Carter to respond on behalf of the Lewis County Superior Court. That's in Lewis County's Exhibits 1 through 11. That's in our declarations. That's an uncontroverted fact that Lewis County never responded to Mr. Cortland's request. The second thing is Lewis County never produced documents, which violates 42.56.070 section 1. And Lewis County is under a duty in order to produce documents and to make them available. And so there's no authority for what Lewis County did. And they didn't even perform a search. So things that aren't even in the codified section of the Public Records Act, such as a search. And Lewis County didn't even perform the search. And Ms. Parker, who is the court administrator for the Lewis County Superior Court, made the search. And so the Neighborhood Alliance case, it's Neighborhood Alliance, and I don't have the site off the top of my head. But
I'm familiar with the case.
It's from the Washington State Supreme Court in 2011. It states that the agency must perform the search. So even case law, it doesn't go against case law. And Lewis County doesn't argue that the laws should somehow be applied differently and be applied to non-agencies. They just basically say, look, the Superior Court can produce these documents without giving any legal support whatsoever. There's no legal support under the Public Records Act. There's no legal support under the stare decisis and very clear case precedent of Ness versus Michaels, of Koenig versus Federal Way, and other cases. And let me bring this court's attention, because I know I filed this yesterday because I was just going over documents about this court's ruling in a separate case involving both Mr. Cortland and Lewis County. And that's case number 16-2-03960-34. And this was from a January 19th, 2018 ruling on the PRA penalty in that case, where actually this court, Honorable Christopher Lenise, ruled that on pages 2 and 3 that, quote, as for the need to deter future misconduct of the defendants, counsel for the defendants has represented to this court at oral argument in this case, following the court's ruling on the merits, the defendants would be complying with the Public Records Act in a manner consistent with this court's ruling on the merits of this case. This court relies upon that representation in finding that aggravating factor need not be present in this case. This representation benefited defendants and was accepted by this court. Thus, the defendants are judicially stopped from taking any inconsistent position in the future. And what this court noted, which is pertinent to this case, both these cases are about the Lewis County Law Library Board. Mr. Cortland, in both cases, asked for records of the Lewis County Law Library Board. In this court's ruling on the case 16-2-03960 in the merits, this court ruled that as a matter of law, Lewis County was required to have a law library board because of the population and because of the plain language of RCW 27.24.020 section 2, and that the Lewis County Law Library Board did not exist at the time of the lawsuit, as it does not exist, I assume, at the time of this lawsuit either. But that was not a bar for the action. So Mr. Cortland was still able to prevail in that action in a Public Records Act lawsuit, even though the Lewis County Law Library Board did not currently exist. Furthermore, the Public Records Act definition of agency does not include the judiciary, and that includes the Lewis County Superior Court. I don't think they'll be disputed that the Lewis County Superior Court is a part of the judiciary. And then the court further ruled that as a part of the judiciary, for purposes of determining whether the entity is subject to the Public Records Act, it performs a membership and function test. The court found that the membership and function test weighed against the Lewis County Law Library Board being a part of the judiciary. And then the function part of the membership and function test stated that it was a traditional part. It was not a traditional part of the judiciary, and it was a county agency. The court went on to find a public records violation, and so Lewis County is judicially stopped from taking any inconsistent positions in this case. So, in other words, Lewis County had to argue how, under the Public Records Act, it complied with the Public Records Act, because it told this court that going forward it was going to comply with the Public Records Act. And Mr. Cortland still has not received a 5-day letter pursuant to RCW 42.56.520 from Lewis County, nor has he received any documents from Lewis County pursuant to RCW.42.56.070 section 1. And I'll just leave it at that. Thank you, Your Honor.
Thank you. From Lewis County?
Thank you. I think, just to make sure the record is clear, the declaration that Mr. Thomas has been referring to in his discussion of estoppel was filed today. He did give a copy of it to me, and I've read it. But it wasn't in his opening briefing for this, and so I didn't know the issue was coming. But I want to underscore that I believe that Lewis County's position is consistent with Your Honor's ruling. I intentionally intended to frame it in that way because Your Honor's ruling was that the Superior Court's taking over the Law Library Board, which is not contemplated in the statute for law library boards, and Your Honor ruled was unlawful, could not shield the Law Library Board's records from the PRA. And Lewis County accepts that ruling, and if it wishes to challenge it, it do so on appeal where it's appropriate and not here. But the other side of that ruling, the other side of that coin, is that if the Superior Court in some sense assumed the PRA obligations of the Law Library Board when it took it over, then by the same token, when it responds to requests for the Law Library Board records, those responses should be deemed effective, because after all, the point is to try to get those records out to the public when they request them. Ultimately, I believe that the argument that Mr. Thomas has articulated is the one that Your Honor had in mind when you first decided the summary judgment motions, which is he finds fault and takes issue with the fact that it was not the right person, wasn't the right agency, and they had the wrong legal designation when they did the search. But those are formal and legal distinctions, and Your Honor's ruling in this factual context was a functional one. Here are records related to this government activity. Those records are meant to be open to the public. They should be released upon request. And in this circumstance, they were released upon request. And they were released with all the sort of typical trappings that you would see in the Public Records Act, except for that the person performing the search and giving out the records was the public records officer of the Superior Court, rather than the public records officer of Lewis County. And under those circumstances, when whichever agency was in control of the records, by whichever legal theory, produced those records, they satisfied the PRA, which takes as its goal and aim to incentivize agencies to do that. It does not require that they identify the precise theory by which the records are available. It does not require that they identify themselves in the right way. But it does require that they give out the records, because that is the point of the act. If Your Honor has any further questions, I can answer, otherwise I'll rest.
I do not. Rebuttal or reply?
Yes, Your Honor, I'll just make a real quick reply. This court can't take the Public Records Act in a piecemeal fashion. This court can't parse out RCW 42.56.030 and say just as long as the records are provided, all the other mandatory requirements of the Public Records Act don't matter. Which is, in fact, what Lewis County is arguing today, that, well, the point of the Public Records Act in RCW 42.56.030 says to get the records, and Mr. Cortland would agree with that. But to qualify that, in order to get the records, it needs to be from the agency. And
You want to slow down just a little bit?
Oh, sorry. I apologize. But in order to effectuate that, it needs to be from the agency. The agency needs to give a response. The agency needs to produce the records. The agency needs to do the search. It's an uncontroverted fact that the agency did not, Lewis County, nor the Lewis County Law Library Board, perform any of those mandatory functions. And so, just to conclude, the court can't take the Public Records Act in a piecemeal fashion. It needs to look at the whole statute as a whole. Thank you.
Thank you. The court is prepared to rule at this time. I am finding in favor of Loomis County in this instance, and I will explain why. The Public Records Act is a critically important statute for the transparency and effectiveness of our democracy. It goes to the core of our freedoms as citizens, and it is critically important that we stay true to the overarching purpose, which is transparency and disclosure in this state. In my ruling in the prior case, it was very much in that spirit that I ruled that although the Law Library Board no longer existed, that arguments that those records were somehow shielded from the Public Records Act were very much a form over function type of analysis that would fly in the face of the purpose of the Public Records Act. The flip side of that coin as we stand here today is that I believe that in this case, to argue that although there is no showing that the search was inadequate, and in fact their showing has been made that the search itself was adequate, and that there is no showing that there are documents that were responsive that were not turned over. In these circumstances, the purposes of the Public Records Act have been applied and satisfied. The issue specifically here as to the identity of the person turning over the records and the identity of the person conducting the search, this court considers to be one of first impression. We have Neighborhood Alliance in other cases, including the statute that says that the agency needs to perform certain tasks. But as we've seen, and the parties are well aware, the definition of the agency in this case, and who is part of that agency, is a unique and more complex than we customarily see in these cases situation. To satisfy the obligations to conduct the search, I am finding in this case that given that the Superior Court has adopted the functions of this Law Library Board, that the search that was done here is appropriate and there is no violation of the Public Records Act. I am aware of the disagreement and that I have agreed with that the Superior Court should not adopt the functions of the Law Library Board. But that issue in terms of requiring or relief or anything directly related to that is not before this court in this case. The question is whether or not documents were turned over and whether the adequate search has been done. And given the factual circumstances of this case, I am finding and concluding that that has been satisfied under the Public Records Act, and I am finding no violation of the Act as a result. Do the parties require any clarification regarding my ruling?
Yes, I do. This court just ruled that given the Superior Court has adopted the function of the Law Library Board, that there's not a violation. Is this court then saying that the Law Library Board is an agency, or that the Superior Court, when adopting the function of the Law Library Board, is an agency pursuant to 42.56.010 Section 1? And second of all, is this court overturning Nass versus Michaels, Koenig versus Federal Way, and the other cases that state that the judiciary is not an agency pursuant to the Public Records Act?
I'm going to allow my ruling to stand. So I'm not answering that question. Clarifications regarding the ruling other than that?
I prepared an order, which of course I didn't have the benefit of your recitation. I think that it's possible that if Your Honor reads it and Mr. Thomas reads it, that you may be able to modify it here today to match what you said. If you're comfortable doing so, would you be willing to look at it?
I will look at it because I know in the past in these cases, the presentation of order itself has been somewhat involved, and I would rather do that right now, given that we have the time. So actually, why don't we take a brief recess to allow everyone to look at this because it's a couple pages long. And I will come back in about 5 minutes and we can take this matter up again.
Thank you, sir.
Recess. This looks to conform with my ruling. I am curious if Mr. Thomas disagrees.
Yes, I do. I would request just a few more minutes. I'm finishing up the conclusions of law.
Okay, so I am going to address, ma'am, if you want to approach, we'll stop this matter.
So, I'm Joseph Thomas on behalf of Plaintiff by Cortland. Just so the record's clear, and the facts first of all, this court, under paragraph 2, it says Mr. Cortland received timely responses to each request. It needs to be clear that these responses were made pursuant to GR 31.1 for appellate review. They can't be confused, and there can't be any ambiguity whether these are, as a matter of fact, whether these responses were made under the Public Records Act.
Doesn't paragraph 3 clarify that?
Okay, I'll rescind that then. I think as a matter of fact then, there needs to be a paragraph added into the facts that the court made the search, that the Lewis County Court Administrator Susie Parker made the search. That was germane to this court's first question. And then I think there also needs to be a factual paragraph added in there that the court produced the records as well.
Okay, and additional changes that you are suggesting?
Conclusions of law number 1, I don't believe that this court ruled as a conclusion of law that there was some that there wasn't some final agency action. I believe that this court said that it was sufficient for the Superior Court in order to produce the documents. This is a totally separate legal argument than what we were just having. Because the production of records was already done, and Hobbs talks about when it's a midstream suit, when documents are still being produced. That's not applicable to this case. Conclusion of law number 2 talks about when an agency produces records, and this court didn't rule that an agency produced records. Under RCW 4256.550 Section 1, the court ruled that a judicial agency produced records, which needs to be clarified for appellate review. Again, in paragraph 3, I guess that's clarified by the other paragraphs are clarified, that the immediate response was provided by the Superior Court and not by an agency pursuant to the Public Records Act, because this is going to be appealed and these ambiguities need to be clear. In paragraph number 5, It says that an agency may satisfy a Public Records Act request by providing the records. An agency did not satisfy the Public Records Act by providing records. The Superior Court satisfied the Public Records Act by providing records. Paragraph number 6, it says, by the same token, however, the Superior Court's response to the Public Records Act even here was effective in satisfying those obligations. I guess that's in accordance with this court's ruling that the Superior Court fulfilled the Public Records Act. I think those are all the corrections that are objections that I would make.
Okay, so I'm going to sign this as is. I believe that much of your objections went to either requesting clarification that it was the Superior Court that did the actions here. I believe that that is uncontroverted, and it is also clarified in paragraph 6 here that says the Superior Court's response. I think the record clearly reflects that. It isn't necessary for me to make that explicit ruling in reaching my conclusions, or finding, I should say. Alternatively, the issues with the conclusions of law, that was with reference to statements of law that were recitations of standards without directly applying that to this case. By the time we were applying them to the case in the later paragraphs, I believe that the ruling is sufficiently clear. So I hear the exceptions. I am going to sign the original form as proposed by Lewis County. I am signing it right now, and that concludes this matter. Anything else this morning?
No, thank you, Your Honor.
Thank you. Court is in recess. Have a good weekend.